provisions, then the Sixth Amendment is more specific. Here's what it says. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So this explains what a fair trial looks like. It must be speedy, which most states define in their constitutions, but usually means that you can be held for 45 days before you have to have a trial, unless you waive this right in order to prepare a stronger defense. The trial should be public, no royal courts or star chambers, because transparency is supposed to make them work better. You have the right to a jury of your peers, not a jury of policemen or government officials or people who are basically likely to convict you, although you can waive your right to a jury. And the trial is supposed to be where you committed the crime, although this doesn't always apply exactly. You have the right to know what you are charged with, which makes total sense because if you didn't, it would be pretty hard to put up a good defense, and you must be able to cross-examine the witnesses brought against you. Probably most important, you have the right to an attorney, although according to the case Gideon versus Wainwright, this only applies in felony cases, which I suppose makes sense because these are the ones that are likely, if you lose, to result in loss of liberty or even life. Because the legal process, as I hope you're beginning to see, is kind of complicated, you really need a lawyer if you're ever going to